All right, we have just been discussing the elements of a persuasive story in closing. Now what I'd like to do is talk about how you use the organization or the format of closings to your advantage. And there is a very specific format to the presentation of closing argument. This is true in criminal cases, and this is also true in the mock trial competition that you'll be doing this next spring. The format is that first of all, we hear from the prosecution or the plaintiff. The prosecution will first speak in closing argument. Second, we will hear from the defendant, the defendant's attorney. And then finally, the prosecution will have one more chance to speak lastly to the jury. So again, first we hear from the prosecution, then we hear from the defendant, and finally we get a chance to hear from the prosecution as well. First of all, the prosecution will go first and present his or her argument in chief. In other words, lay out the entire theory of the case. And at this stage, the prosecution must be comprehensive. Remember that the prosecution has the burden of approving all of the elements of the case, and failing to address an element is absolutely fatal to the case. So again, remember our analogy with the milking stool, the Dayenia taburetka, that if the prosecution does not mention and does not cover all of the elements, then the case must fall, just like this milking stool will fall to the ground. So if your prosecution in your mock trial, it is so important that you cover all of the elements of the case. The next stage, of course, is the defense making argument. And the defense has more latitude and more freedom in how to present the case than the prosecution. The prosecution must address all of the elements of the case or the case is over. But the defense can be much more free and creative in how to approach closing. For example, the defense the prosecution, remember, has to select only one or two elements in which the defense has the most confidence in, or excuse me, the defense can attack one or two elements only. So whereas in the looking at the milking stool, the Dayenia taburetka, the prosecutor under level 1 has to address all of the elements of the case, but the defense can simply attack one leg or attack two legs of the case and say, sure, the prosecution has proved these things, these elements, but has failed to establish the other two elements. So that can be a good strategy for defense counsel. Remember, by the way, getting back to the format, remember that the defining characteristic of the defendant's argument is that it is sandwiched, or it is placed between the two arguments made by the prosecution. So the defense must respond to the argument in chief, but will not be able to respond to the rebuttal. So in a sense, the defendant has to anticipate what the prosecution is going to say in its rebuttal argument. This can be a very difficult thing, especially for a defense attorney, to know how to craft the closing argument to respond to the rebuttal. You have to be very fluid. You have to be very open. It is sort of like that statement from the American boxer Muhammad Ali that I float like a butterfly and sting like a bee. That is what you need to do as a defense attorney, is you need to float. You need to be like a butterfly. You need to be able to move quickly from topic to topic. You need to be able to change your strategy on your feet. But when you make a knockout punch, you need to make it sting. You need to hit hard on the strong parts of your case. So let's talk again about how the defense is going to respond to the argument in chief. That is part one. So how does the defense respond first to the argument in chief? What you do is you address the major points. You want to spend some time devoted to tearing down the prosecution case, or debunking, let's say, the prosecution case. But again, as I said a minute ago, the watchword is really flexibility. You have to be so flexible. You have to be able to respond on your feet to arguments that are being made by the prosecution. The prosecution can really plan every aspect of its argument in chief, but the defense, in presenting its response, has to be alert to new issues that come up either during the trial or during the prosecution's closing argument. A particularly effective device is to use the prosecution's own theme. And remember that each side is going to come up with a theme, but if the defense can somehow co-opt or steal or use the prosecution's theme and twist it a little bit, that can actually be very, very, very effective and turn it around on the prosecution. So, for example, if in the firefighter case, if the prosecution's or the plaintiff's theme was that the defendant was too busy to be careful, the defense might steal that theme and say that my client was busy, and so he had to be careful. You know, that'd be an example of how you might steal or co-opt or use a theme from the other side.